Hey there, Amicus listeners. Before we start the show, I want to let you know about a story that's coming up a little later. It's from one of our partners, SAP. AI comes at you fast. If you don't get reliable and relevant advice, your business might miss out. Whether you're looking to automate tasks or embed AI in your business processes, SAP can help. To learn more, head to sap.com/AI and stick around for expert advice on how to embrace AI with confidence.
This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Hi, and welcome back to Amicus. This is Slate's podcast about the courts and the law and the Supreme Court. And I'm Dahlia Lithwick. And I don't know about you all, but I am pretty freaking exhausted. When we decided to take the show weekly this past fall, I'm not sure we realized that every week would contain 10,000 years. So this was a lot of news to pack in. And there appears to be a lot more news in the world of the law where that came from. So this is going to be my last Amicus podcast for a couple of weeks as I take a little break to recharge and maybe look at the sky, get some sun on my face. And as we all steel ourselves for what is going to come in the legal world this fall. And I just want to say from the bottom of my heart that if you are feeling depleted and frustrated and tired, I really hope you get the chance to rest a little bit too in August. But fear not, dearest listener, my little mini break does not mean you are going to be amicus-less in the month of August. I am extremely excited to share that Andrea Bernstein will be stepping in and bringing down the house with a really timely and, I think, perspective-affording series, especially for us here. It's a series that we're calling The Law According to Trump. You may remember hearing from Andrea here on Amicus when we interviewed her about the series she made with ProPublica about the rise of Leonard Leo and the Federalist Society. The show was called We Don't Talk About Leo, and I'm just going to say it was the best thing I've heard on the man behind the everything that is happening right now, bar none. But Andrea is also known for extensive, unparalleled investigative work on the Donald Trump law and corruption beat. She is a Peabody and DuPont Columbia award-winning journalist who co-hosted the Trump Inc. podcast at WNYC. Her book, American Oligarchs, The Kushners, the Trumps, and the Marriage of Money and Power, is a really vital, I would say indispensable primer for those hoping to better understand the particular vectors of money and power in Trump world. Andrea was also co-host of the incredible Will Be Wild podcast series about the forces that led to the January 6th insurrection and its consequences. And she's with me now to talk about what's coming up on The Law According to Trump on Amicus this August. So, Andrea, welcome back. And holy hell, I'm so excited that it's you who's going to be in the chair for the next month.
Yes, and I'm excited too. And also, trying to fill your very big shoes. I actually have no idea what size shoes you have, but
my shoes are
they're
vast.
large in my head.
They are vast. I'm a very short person with massive feet. So
there you go. You do have large shoes.
There's the paradox. I would love for you to tell our listeners what The Law According to Trump is all about.
So I have been covering all of the cases against Trump in sort of criminal and civil courthouses brought by the New York Attorney General, the Manhattan DA, the civil cases brought by writer E. Jean Carroll, all of the sort of big post-presidency New York cases. But there is so much else going on when it comes to Trump and litigation, and so much that's really important to understand about how he operates and what he did when he was president and what he did in his post-presidency and what we might expect from him. So one of the things we're going to sort of start by looking at is just his history of litigiousness, which is just sort of really outsized, but also to look at some of the things that have kind of gotten lost in the sauce. For example, all of the civil cases that have been brought against him for his role in January 6th. There's been a lot of focus on the criminal cases, but there are a number of important civil cases that are using this tool from the Reconstruction era, the KKK Act of 1871, to sue Donald Trump and his cohorts. So we're going to get caught up on those cases. And we're also going to look at some things like how Trump used the pardon power in his presidency and with what result? What are the patterns? What are the expectations? What could happen in another Trump presidency?
You know, obviously, listeners are coming to this on the eve of what feel like a couple of spectacular defeats for the rule of law, you know, between the immunity case going up to the Supreme Court and, you know, questions of whether the New York prosecution even survives after that. And then, of course, Judge Aileen Cannon in the Mar-a-Lago case saying like, I think that I'm going to just bat this away too. There's just a sense, I think, out in the world that maybe the law just is not sufficient to contain whatever it is that chaos, Muppet, Donald Trump brings. And I wonder if in thinking about and researching this, your answer is more nuanced. If there's a sense that this is not that the law is too technical or too slow or too reliant on big money, that there's some layer here that we're missing about how the rule of law is not necessarily down for the count.
Well, I am of many minds about this. Just to take one example of the cases you just mentioned, the immunity case. Here was a situation in which once the case got to the full D.C. Circuit and they came down with their full court decision, it seemed like it was airtight. Judges appointed by Democrats, judges appointed by Republicans, all agreeing. Everybody said, well, that's it. I mean, what can the Supreme Court do? And then we saw what the Supreme Court did, which was go further than anybody expected. And that is a situation entirely because Donald Trump will never throw in the towel, and he will keep pushing and pushing and pushing and pushing until he can't push anymore, and then he will push even more. So here's a case where we result in this ruling, and it just makes you feel like, wow, how can you sort of pick up the pieces and go from there? On the other hand, even though I've seen so many juries at this point say guilty, liable, guilty, liable, there was a sense that Donald Trump was escaping all consequences. And yet, I will tell you a story, which is that I happened to be seated when the verdict was read, and in the row right behind Donald Trump's legal team, and just 2 rows behind Donald Trump. And when he stood out and sort of shook hands with his son, Eric, in kind of regretful handshake, he looked stricken. And I have never seen him look stricken in that way. And I thought to myself, for whatever fleeting moment, there is a moment of accountability. So even though I've covered all these cases, and I feel along with everybody else that sort of what holds him accountable, what sort of brings him down to earth, and sometimes it seems like nothing. And yet I still believe in the possibility that the system can work, which I realize is sort of contradictory and crazy. And it's kind of also the way I feel about journalism, which is sort of, what is it going to do? But what else can you do but to practice good journalism and bring out the truth of situations?
Right. I always have to remind myself there's no plan B. You know, if journalism fails and law fails, like plan B is like what? Interpretive dance. Like we're in big, big trouble. I wonder if you can just tell us what you're hoping listeners are going to take from a series that's about sort of Donald Trump, his ongoing relationship with the law, and how he's learned to, weaponize it, but also leave just a trail of broken lawyers and legal systems in his wake. What are you hoping folks heading into the election can kind of put together from this project in terms of thinking more systematically about Donald Trump and the law?
Well, one of the things that's really interesting and that we're sort of seeing as Kamala Harris begins her campaign for president is the way in which she really wants to talk about all these legal cases against Trump. And she wants to draw the line from herself as a former prosecutor and Donald Trump. And I think that is really interesting because I think it's been quite some time since we had a Democrat who wanted to talk about Donald Trump in that way. And that sort of, kind of puts it into the discourse in a way other than how Trump has been raising it, which is, I am the victim. I am the victim of a sinister system that just wants to sort of put me down and block me. So I think that will be interesting. But I think that what I am hoping that people come to understand is sort of the full range of the legal world in which Trump operates and, sort of what it means and to understand the broad context behind his legal moves. Because I think that it's hard to see. It's hard to see what he's doing when you get caught up in the day-to-day. And I'm hoping that this series is a moment to reflect and for people to see big patterns and to sort of, kind of understand the world and understand it in a way that is not just falsifying business records, hush money, sexual abuse, sort of all of these kind of technical and smaller decisions, or, even the bigger ones like SEAL Team 6 and how the special counsel is appointed and funded, but how Trump has used and will use law to his advantage and what that means for the legal system. And then people can draw their own conclusions about what they want to do about it.
Andrea Bernstein will be stepping in and teaching you and me everything I wanted to know about this kind of law of Trump, trademark, Trump trials, trademark, all of the material we've tried to cover in the mayhem of the last couple of years. It's going to be a series made especially for us. We're calling it The Law According to Trump. Andrea, I cannot wait to see what you unearth.
Thank you, Dahlia, and I hope you get some very, very, very well-deserved rest.
Let's pause to hear from some of our sponsors.
This podcast is brought to you by Slate Studios and SAP. AI is moving so fast. If you don't get reliable and relevant advice, your business might miss out. Welcome to Dear Artie, an advice column from SAP, where we tackle the tricky questions at the intersection of AI and business. Here's our expert, the technology futurist, Ian Kahn.
Hi, I'm excited to dive into today's question.
Dear Artie, as our company expands, so do our hiring efforts. How can AI help us attract top talent? Signed, Searching for Higher Power.
So, searching for higher power, one of the most daunting undertakings of an HR leader today is building a new team and finding and vetting new talent. This is a very time-consuming process and can take precious organizational resources. As a companion to the HR team, AI technology can be used to create job descriptions, analyze candidate resumes, and filter candidates into various pools based on experience, skills, or any other parameter. You can also use AI to match internal talent with positions available. Parameters for this can be set, rules can be set, that can all be done through the algorithm. There are so many things that we as humans could be not looking at that AI can do in a matter of seconds.
Embrace AI with confidence. Head to sap.com/AI to learn more.
This episode is brought to you by SAP. First, the bad news. SAP Business AI won't help you generate cubist versions of your family's holiday photos. but it will help you understand which supplier is best to help you roll out your plant-based packaging in Southeast Asia, identify the training your junior project manager needs to rise up the ranks, and automate repetitive tasks while you focus on big innovations, so you can be ready for the next opportunity. Revolutionary technology, real-world results. That's SAP Business AI. And now a bit of a treat for you, definitely a huge treat for me. Last week on the show, we had the opportunity to hear from one of the world's most respected jurists. And today we're going to get to hear from another truly exceptional judge who is also sounding the alarm about what has been happening at the U.S. Supreme Court and to the rule of law in the United States. Now, I've known Judge David Tatel for close to 20 years. He stepped down recently after 30 years on the D.C. Circuit Court of Appeals. That's known as the second most powerful court in the land. Judge Tatel was on all sorts of Supreme Court shortlists over the years, and I just want to tell you, his list of former law clerks make the world better every day. It would astound you what his clerks have done. Judge Tatel has also been blind for almost half of his life. And his new book, Vision, which came out in June, combines the stories of his loss of his eyesight with his life on the bench. As he notes in the introduction to the book, he has found acceptance with respect to the loss of his sight, but he is ever more worried about the direction of the Supreme Court and the law of the land. Judge David Tatel, this is just a ridiculous honor and a pleasure. Welcome to Amicus.
It's my pleasure to be here, Dahlia.
So I think I want to start with your opening chapter because it's a little bit of a snapshot of what is going to be a critique about how the court, the Supreme Court, and the entire legal system is more and more concerning for you. On the one hand, it's a story of a kind of death penalty appeal that passes through your hands, but it's also a story about a demand for exigency, a disregard for facts, a disregard for fact-finding in the court below. And so I wonder if you can just, by way of kind of locating us in this conversation about where you are at the moment in terms of the courts and the law, why you picked this story to launch the book and what it signals about what you're worried about in terms of the court above.
I thought a lot, Dolly, about how to start the book. And I picked that case because this was a capital case, the first of the Trump administration's executions. I picked the case because, first of all, it was a simple story to tell, but also I thought it was emblematic of my concerns about this court. The case came to us, that is, to a panel in the D.C. Circuit, from a district court who had enjoined the execution because the defendant claimed that the chemical that the government would use to execute him would cause terrible pain and suffering. And under the Eighth Amendment, defendants are entitled not to a painless execution, but to one that isn't extraordinarily painful. The district court found, based on expert testimony, that there were competing views about whether or not this chemical would cause unconstitutional pain or pain that would violate the Eighth Amendment. The defendant had one expert, the government had another expert, and the district court did what the district court is supposed to do, enjoin the execution to give her time to have a hearing, to consider the evidence, and to make a rational judgment about what, in fact, this chemical would do to the defendant. It came to us in the middle of the afternoon. The execution was supposed to occur that evening. We two, the panel, the other two judges, one appointed by a Republican a president, one by a Democratic a president, like myself, we looked at the record and reached pretty much the same conclusion. The district court had done her job. She had concluded that based on the record, she couldn't resolve the factual dispute. And so she enjoined the execution, as did we. we affirmed her decision and set a very fast briefing schedule. The government was insisting on speed, and we gave it to them. We ordered briefs filed within just days, but we enjoined the execution. While we were working on the case in the evening, we got word from the Supreme Court clerk's office that the Supreme Court wanted us to resolve this case quickly, preferably within the next hour, which we did. We issued our opinion, and within an hour or two of issuing our opinion, the Supreme Court issued an opinion vacating our stay and allowing the execution to go forward. It was 5-4, split along political lines. And the thing that concerned me the most about it was that the majority opinion of the court acknowledged the factual dispute, but ordered the execution to go forward anyway, emphasizing the need for speed, and the defendant was executed the next morning. That isn't the way courts are supposed to work. Here you had a case where a human life was at stake. There was no question that this defendant would eventually be executed. The crime he committed was heinous, and no one on his behalf claimed he was innocent. The only question was how he would die. And yet, even though there was conflicting evidence in the record about whether the particular chemical here would cause unconstitutional pain, a conflict that the Supreme Court itself acknowledged, it went ahead and allowed the execution to go forward. And to me, Dahlia, that's emblematic of the problem with this court. Our courts are one of three branches of our government. The checks and balances are absolutely essential to the protection of citizens from the abuse of governmental power. And the courts have potentially enormous power over the other two branches of government. And the only thing that's preserved this separation of powers is that the courts have restrained themselves over the years. And they've restrained themselves by following a series of principles to confine courts to the judicial function and keep them out of policymaking. And one of those is that courts of appeals don't find facts. We have a very effective method of finding facts in our judicial system. Trial courts do that. They hear evidence, they hear the conflicting witnesses, and they find facts. And courts of appeals and the Supreme Court are bound by those facts unless they're clearly erroneous, unless they're clearly wrong. And here was a case where the district court had made it quite clear that it hadn't yet found the key facts, yet the court allowed the execution to go forward without resolving the dispute at the heart of the case. That's not a principled judicial decision.
Judge, I was struck by the choice to start with this story because it feels like it really centers two of the critiques of the current Supreme Court. One you just noted, which is, either we don't have time to look at the facts, or we don't have even time for the other courts to find facts or get facts or determine facts. And that raises the second question, which is, what is exigent, right? And right now we are having a huge national meltdown about a Supreme Court that is capable of working quickly in some situations, not in others, that sort of responds to emergency motions sometimes, but not other times. And this sense that this question of what is exigent for the Supreme Court's purposes filters into this question of, do we have time to look at the facts? And so I guess to me, I would love if you have some theory, and I think you lay out in the book that the preference is always that courts go slow and deliberately and are meticulously careful, and that sometimes they have to act quickly because there is real exigency. But it feels as though if there is a current theory of exigency at the Supreme Court, I don't understand it. And I certainly don't understand it when the issue is, as you note, we just need to execute this guy really quickly.
Well, death penalty cases are a category all by themselves, Dahlia. My court doesn't get very many of these. In fact, this was one of the first, if not the first, death penalty case we had. There is no death penalty in the District of Columbia. And although there's a federal death penalty, my court just hadn't had any of those cases. So they're not the kinds of cases the D.C. Circuit hears regularly. But if you look at death penalty jurisprudence, particularly with this court, The court's view, I think, is, if you read their opinions, is that executions are delayed by the lawyers who represent the defendants. And several of the justices have complained about that. That happened at an earlier stage of this very case, when the question was whether the protocols through which the Justice Department would execute these prisoners was legal, whether it actually complied with the Death Penalty Act. And I had the first stage of that also in the court. Even there, although it allowed the D.C. Circuit to decide the case, it made it very clear it wanted us to decide the case quickly. Now, that's not a problem in most situations. It makes sense that there are circumstances under which courts have to move very quickly, and our courts are capable of doing that when they need to. The Watergate tapes case, I think, went through the courts in 9 or 10 days. The Pentagon Papers case went through in less than 2 weeks. So courts can function quickly and function well when they want to. The problem in the death penalty situation is that a human life is at stake. If you make a mistake, you can't correct it. And so, at least as a judge sitting on that case, it seemed to us, all three of us, that yes, we would move quickly and expeditiously, which is what the court wanted, but that we could do that and still resolve the factual dispute at the heart of the case. And if it turned out that the chemical would cause unconstitutional injury or suffering, the government would have to find another way to execute the defendant. If, on the other hand, we resolve the factual dispute in a way that suggested that he would not suffer unconstitutional injury, he would be executed. It was just a question of time. Tom Wicker once wrote a book about Atticus and the prison situation in New York. And I've always been impressed with the title of his book because, as you know, what happened there was the prisoners had taken over the prison and the governor sent state forces in to take the prison back, and many people died. And Tom Wicker's book is called something like A Time to Die. And his point was, there's always time to die. We should take our time and get these things right before a human being is executed.
Judge, I feel like this whole book is bracketed by a kind of love story between you and science.
Yes.
And maybe you and your dad, who died when you were young, tragically, and his love of science. And not just, the fact that your, I think, original grounding was in the fact-finding of science, but also the ways that maps onto the way you think about the law. And I would just love for you to expound a little bit on, you've got this lovely section where you talk about going on a trip to Peru with your dad. And there's a lovely section where you say, I look back on Peru as my earliest exposure to rigorous analysis and principled collaborative decision-making, beginning with a hypothesis. The scientists collected and examined data, debated possibilities, listened to each other's views. Using different tools, judges do the same thing. And I would love to have you, because I feel as though so much, at least at the Supreme Court level, of opinion writing that I read now is rooted in feelings. If you could talk a little bit about how you see the scientific method and the judicial method as intrinsically connected.
Yes, they're actually connected, at least in my mind, quite substantially. The story, Dahlia, there is, to make a long story very short, is that I was 15 years old and on a scientific expedition to the Peruvian Andes with 7 or 8 scientists. And they were exploring or trying to understand the thickness of the Earth crust. And they had theories, they had a hypothesis about it, but they were there in Peru to collect evidence. And they fanned out all across the Altiplano, and I had my own little seismic station. And we would collect data during the day. And then every night, we would go back to the hotel as a group, and I would sit around with these wonderful men. They were all men then. And they would examine their data, including the data I had collected. And then there would be a discussion. And these scientists would try different ideas out on each other. They had come there with a hypothesis and they were collecting evidence. And the more work they did, the more they began to understand what the facts, in fact, were. I was just a 15-year-old kid then, but I was totally struck with the process I watched there. And now as a judge, and I've kept up my interest in science throughout my career. I've served on the scientific committee at the National Academy of Sciences. I read deeply in science and science biographies. And I love, one of the reasons I like being on the DC circuit is that so much of our cases rest on scientific evidence of one kind or another. And when I handle these cases, I often think back to those days when I was in Peru with my dad, because when we're hearing a case and then discussing it afterwards in our conference, we're doing very much the same thing my dad was doing with his colleagues. My colleagues and I, we've collected the facts. In Peru, we collected the facts through scientific evidence. On the court, we collect the facts that are developed by the district court or by the agency. And we have our own ideas about where things might be and where the case should go. But just like scientists have hypotheses, they apply the rules of science, principles of science. And just like we approach cases with ideas about what's right and wrong and which way the case should be decided, we too operate under rules. They're not scientific principles, they're judicial principles. And we're applying those principles and the law to the facts that we found. Very similar to what those scientists were doing 15 years ago. And that process has also, Dahlia, given me, just as a judge, a great deal of assurance. One of the scariest things I found at the beginning of my time on the judge is how do you decide these cases based on the law and not your own policy preferences? That's very hard to do. And just as my dad and his colleagues forced their decisions to flow from the principles of science, I found it very reassuring to work to make sure that my decisions flow from legal principles, from the statute, from the Constitution, based on facts that the district courts have found. So the processes are very, very similar. We use different terminology, but scientists and judges are actually engaged in a very similar process.
It's fascinating that you say this because on your section on your own sort of judicial philosophy, and you describe exactly that tension of, I've been an activist all my life. I've been doing these civil rights cases. I've been doing, education and desegregation. And I have to check myself that I'm being a judge and not being an activist. And the things that you tether yourself to, it seems to me, are also kind of components of the scientific method, which is, as you just said, testing a hypothesis, humility, understanding the enormity of what you don't know, kind of doing as little as possible, and then resting on precedent. In other words, you're not reinventing this thing today. You are largely building on the work of others. And it feels to me, again, as though there's a straight line from a kind of childhood immersion in scientific principle and the ways in which, even as a judge, the understanding that I am here in some sense to try to learn this tiny thing, but there's an enormous quantum of stuff I don't know. And so I'm not going to screw everything up. It feels that that humility is also of a piece with this view of science.
Yes, that's absolutely right. The humility drives you to look for a solid basis to make the decision that's other than your own judgment. I cannot emphasize enough the importance of facts. You cannot decide a case without getting the facts correct. And as I said earlier, our trial courts have about the best system for finding facts that we know of. It works pretty well. It's not perfect, but it works pretty well. And returning a bit to the problem of the current Supreme Court is that instead of limiting itself to the facts found by the fact finder, that is the district court or the administrative agency, this court often disregards that fact finding and does its own fact finding. That was true in Shelby County. where the court, even though Congress had found that voting discrimination in the South continued and justified continuing the Voting Rights Act, the court decided on its own that the South had changed. South Carolina case, court, instead of deferring to the extensive district court fact findings, switched the burden of proof and ignored them by developing a presumption of good faith for the state legislature. So what we have here, just as in the death penalty case at the beginning of my book, where the court refused to allow the district court to resolve a key fact, its tendency now is to disregard the fact finding of Congress, of the district courts, and of the agencies. And that's a very serious departure from a very fundamental principle of judicial restraint. The other thing I'd mention, Dahlia, that comes from my experience with my dad way back then on the Peruvian Altiplano, is the collaboration that I saw between these scientists. They had their own ideas and they would state their views and argue about it, but they all listened to each other. And I discovered in my years on the court that that part of judging was just as important to the judging process. In conference, after we've heard a case, there was often a great deal of discussion about what we had heard, including debate about what the facts supported. But when the court was functioning at its best, it was functioning that way because the members of the court were listening to each other. One judge had a particular view of a particular set of facts. Another judge had another view, and we discussed it and listened and with an open mind, and almost always came to consensus about it. And when we didn't reach consensus, we articulated our different views in competing opinions that dealt with the issue. And so in that sense, that collaboration, which I found so critical to the judicial process, I first saw back there on the Peruvian Altiplano when I was just 15 years old.
Let's pause to hear from some of our sponsors.
This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
Pulling up to Mickey D's just for drinks? Oh yeah, that's me. Nothing extra, just perfection and a straw. Coming in hot for the coldest cups on the block. Because there are drinks. Then there are drinks from McDonald's.
Mix things up with any size lemonade or sweet tea for $1.49. Perfect with our classic fries. Price and participation may vary. Cannot be combined with any other offer.
Ba-da-ba-ba-ba.
Let's return now to my conversation with Judge David Tatel. Can you talk a little bit about, it's such an amazing sort of thing to go through this, your early career sort of falling in love with, the Constitution and going to law school and then starting, a series of jobs that were really rooted in this Kennedy era notion that not only can government do good work and help people, but that lawyers are kind of obligated to be a part of that. And both of those feel to me so lost to us, both the trust that government entities or entities funded by the government can actually bring about equality and justice and desegregation and equal opportunities at education, all the things you worked on, that government isn't doing bad, but also that an intrinsic part of that has to be lawyers. And it's strange to me reading this book now how archaic those notions feel because we're so cynical about both government and lawyers.
I think they're archaic at one level, Dahlia, but not at another level. One of the wonderful things about being a federal judge is law clerks. And I've had over 100 law clerks in my years on the court. And Most of my law clerks are very typical of lots of young lawyers in the country today. They are devoted to the same principles I was as a young lawyer. They're out there using their legal skills to protect individuals and to promote equal opportunity, whether they're in a law firm doing pro bono work or working for a government agency or teaching. I think that spirit's still alive and well among vast parts of the legal community. Problem is, it isn't enough. There are also large parts of the legal community that aren't responsive to these. And our legal system is itself a problem because of the cost of legal representation. Most poor people in our country have no access to the legal system at all. And also, historically, I think you're right in the sense that back in the 60s and early 70s, we had all three branches of government, the executive, legislative, and judicial, all focused on equal opportunity in terms of particularly the civil rights movement in the South. Congress was passing civil rights laws. The executive branch was enforcing them, and the courts were enforcing them. That's no longer the case. That started breaking down with the Nixon administration, and although it's had its ups and downs, generally, that powerful use of government to promote equality has been severely weakened, and to a certain extent works the other way now. As a result of Shelby County released state and southern voting districts to start suppressing the right to vote. And so we have a situation where those values that inspired me so much in the 60s are under enormous stress today.
At the end of the day, this is a book about translating and explaining. And I think you're doing two things at once, and it's quite beautiful sort of watching them converge. One is, here's what it's like to be blind. Here's what it's like to be blind on a busy street. Here's what it's like to be blind in a restaurant and people think that I am not shaking their hand because I'm cold because I haven't told them I'm losing my sight. It's such a patient explanation of the 1,000,001 ways that we don't understand if we are sighted, what your life has been like as you've gradually lost your sight. And then simultaneously, it's just this incredibly patient explanation of how the courts work and how the circuit courts work. And it's so unlike judicial writing in so many ways that sort of often prize obfuscation and, jargon and a sense of I'm in the club and you're not, and I'm going to keep you out of the club by making sure that it's not transparent to you. And I would just love for you to talk about, it's such a hallmark of your judicial writing too, this desire to be crisp and clear, but also opening portals between worlds so that people can see what they didn't know before. And I do feel like it's actually a part of the scientific thing that you're doing, which is teaching and explaining.
Yes. Well, I'm so glad you had that reaction to the book, Dahlia. That's very important to me to hear that. One of the basic differences between a judge and a member of Congress is that, a member of Congress can vote yay or nay. That's it. And then they run for election. Judges have to explain their decisions. The integrity of a judicial decision flows from how convincing its rationale is. And it has to convince not just the lawyers in the case, but it has to convince the agencies and ultimately the public. And therefore, I tried very hard as a judge to write opinions that I thought people could understand. Now, that was a challenge when you come to a decision involving the Federal Energy Regulatory Commission or one of the highly technical ones. But with most cases, I tried really hard to produce an opinion that my non-lawyer friends could read and understand. And when I wrote this book, I wanted very much to write a book that lawyers could read, but I had a much broader audience in mind. And I wanted to explain in the clearest terms I could, how both threads of the book, I wanted people to understand how I dealt with declining sight and why I reacted the way I did to it, just as I wanted my readers to understand my views about the courts. And as I said, not just lawyers. I wanted the public to understand it. And one of the reasons for that is that you probably saw in the epilogue, I was convinced to write this book. This isn't something I wanted to do. I had not planned to write a book, but dear friends of mine convinced me that my personal story was worth telling, that it could be inspirational to people who have a disability and to people who don't. And there was no way to write an inspirational book that wasn't clear and understandable. It had to be accessible to your regular readers. And I tried really hard to make that happen. And I'm very glad, Dahlia, to hear that you thought that we accomplished that.
I think the other thing that I'm so aware of reading the book is this story of evolution. And I'm mindful of, we're in a moment where originalism is king. And in some sense, this is a book of you totting up things you were kind of wrong about, right? Chief among them, how long it took you to, sort of accept the inevitability of the sight loss, finally coming to use the white cane very, very, very recently, relatively coming to terms with the fact that you would, and I promise we're getting to Vixen, but be willing to use a dog to help. And in so many places, you cop to the fact, including, the guys who set up the pins in the bowling alley when you were a kid, all of whom were Black, I missed something. I didn't catch something. I almost want to say, Judge, I didn't see something. And time after time after time, including, by the end of the book, when you're saying, I think we were wrong about some of the ways we do clerkships. I think we were wrong about term limits. And it's such a story of kind of in some way being willing to say, here's what I missed. Here's how I course corrected. And I think that stands in either in tension with, I can't decide, or very much supports this larger arc of the story, which is, holy cow, the courts are going off the rails here, and kind of an acceptance and evolution that maybe the law itself is not unerringly working towards, justice and equality. And I would love for you to just talk about, in this moment in time where we put such a premium on, only the framers were right, the law can't change. If it wasn't, the law at the founding, it's bad. And a book that is a journey at so many levels of checking yourself and saying, I was wrong, I would do this differently if I could do it again.
Well, maybe the answer is that everybody should write a book. When I started this process, my friends said I should write a book. So I thought, okay, I can do that, and I'll write a book, and I'll describe, my journey with blindness, and I'll talk about my cases. What I did not understand, Dahlia, never understood until I got into the process, how much the writing process forced me to think deeply about both grades of this book. Many of the conclusions I've reached in this book about how I handled blindness and how I reacted to it and why it took me so long to acknowledge it, and much of my understanding about the court comes from working on this book, because on both sides, on both grades, I had to think deeply about them to be able to write about them. And I also had an editor and an agent who asked very hard questions. And probably most important, my wife, Edie, who is my writing partner in this, asked very hard questions and she's been part of this adventure. And so the points you've just made, so many of those, of looking back and realizing that I could have done things differently, and that the courts could be doing things differently, come from the process of writing this book and thinking about it. I say in the book, when it comes to opinion writing, writing is thinking. You think through an opinion as you write it. Well, that was true of this book in more ways than I ever could have imagined. I don't know whether I've reached the right conclusions about the two braids in this book, but I certainly, as a person, understand them better than I did when I started the process.
maybe my follow on to that is that I know I mentioned in the introduction how hard it is as a judge to talk about the judiciary. And I know, because you talk about it in the book, how fragile public respect for the judiciary is, and that if you are inside the house, you're apt to say everything's fine, because you want to both critique the process, but also at the end of the day, shore it up against attacks. And so I'm very, very curious about, and we had a conversation with a justice from the Hawaii Supreme Court just a few weeks ago about the flaws in originalism. But I am well aware of how hard it is as a judge to level critiques against not just, the current Supreme Court, which you do, but a whole bunch of the processes of how the judiciary is constructed and how we compensate lawyers and all of the ways that you have come to say, maybe we're not getting this entirely correct. And I'm just curious about the process of leveling criticisms at the court about decisions, about some of your colleagues, about some of their decisions, and how that jibes with the general proclivity, I think, of judges to say, we're all awesome and perfect. Also, we are gods who walk among you.
It's a very complicated question. First of all, I hope my criticisms of the courts and of the Supreme Court are supported by what's in the book. In other words, I hope people will look at my criticism of the court in view of the whole book. They won't just take the conclusion. In other words, take my concern about the court's growing lack of faithfulness to its own precedent. I hope when they read that, they'll read the book and they'll decide whether they think I'm right or wrong based on what I've said in the book. I don't want them to react to just my conclusion. Same thing about my opinions. I say to my friends when someone says, why did you reach that result? I say, first question, well, did you read the opinion? And if they haven't read the opinion, I'll usually say to them, well, why don't you read it and then let's talk about it. So I hope people will read my criticism, which, as I said at the beginning of this, flows from my own experience, in view of how I've tried to justify it in the book. Your question, I think, also touches a little bit on how judges talk about collegiality publicly and how it works in practice. It used to be, when I was first on the court, I used to like to talk about how close, good friends judges were on the court, and how we did things socially and knew each other and how important that was. And, the justices do a lot of that today. They talk about how they have lunch together and how much they respect each other. And my views about this have changed because, and I try to explain this in the book, collegiality is critical to judging, but collegiality isn't having lunch together. It isn't going to basketball games together. That's helpful, but collegiality is judges actually listening to each other and trying to understand each other's positions and sometimes even changing your mind. That's judicial collegiality, and that's what's critical to the judicial process. So if you want to understand whether courts are acting collegially, what you want to look at is not what they say, but what they write in their opinions.
I love that in the end, this is a book. It's such an intimate book about, your wife, Edie, truly one of the nicest people I've ever met, about your kids and your grandkids, and about Vixen. And at the same time, it's a book about the future of the whole entire world. And the chapters that I think are hardest to think about and talk about are the chapters toward the end where you are sounding the alarm about climate change and the environmental cases that you have heard about, the future of the EPA, I think you offer the same critiques I have offered about the major questions doctrine and about the non-delegation doctrine and the different ways we are kneecapping federal agencies that are trying to save the planet. And then your chapter on voting rights, which similarly, I think, traces an arc from we were getting better at this, and now we are, you mentioned this in response to one of the first questions, we are discernibly terrible at making sure that people can vote. And in a way, it's a book that is as much about the future as it is about the past. And you land at this place that I think is the only place you can land at in the face of, what you're describing as existential fears for the future of democracy, for the future of the planet, where you essentially say to your readers, do something about it.
Right.
Like, this is not on me. I've done what I can do. But now it's time to get out there and get involved. And I'd love for you to just trace, because it's such an important, I think, message that the judges on high are not going to save you. They're not going to save the environment or democracy. That's going to have to come from you, the reader. Because I think it's very, very hard in this age of celebrity superstar justice doers to understand that we kind of have to be the celebrity superstar justice doers that we want to see in the world.
That's right. I think the two chapters together, the chapter on climate and the chapter on voting, there's two levels of risk. And I will get to your question here. In the climate chapter, the risk is that the federal agencies that have been so critical to protecting the health and safety of the American people could be severely limited by the court. And on the voting side, what's more fundamental to a democracy than the right to vote? Yet the Supreme Court is allowing widespread suppression of the right to vote. Well, both of those are very dangerous to our country. But the other side of that is that the way in which the court is accomplishing that, the decidedly non-judicial means it's using to get there, are themselves threatening to our democracy. And when I finished, I thought a lot about what I was going to say at the end of the book. And people said to me, they said, David, you can't just end the book. You have to have something to say about what are you going to say to young lawyers? What are you going to say to your readers about the future? And the more I thought about it, the more I thought I just came back to this very simple, but I think profound conclusion, which is it's all about voting. How else do we affect our government than by voting? And I plead with my readers to not only vote and not only get all your friends to vote and not only, even if your state you live in makes it hard for you to vote, just go ahead and overcome those obstacles and vote for presidents who will appoint the best judges they can, who will not appoint judges for particular policy reasons, and vote for members of Congress who will take the checks and balances seriously and use the power of the legislature to check the courts as they can. And the same thing at the state and local level. That's really all we have as citizens here is voting. And in the end, that's going to be what ultimately turns us around is the political process.
I want to talk about Vixen.
Of course.
I know you want to talk about Vixen too. So I'm just going to tell you, I think you know this. I'm a cat person. I've always been a cat person. I always will be a cat person. I've gotten into fights with dog people before, but I'm going to give you an opportunity because your book has taught me to be humble and persuadable, to tell our listeners how very much you have come to love this relationship. But also, I think it's another story about you coming around on something that you did not want to do. I slightly love that it was your grandson
Right.
that convinced you to do this, because in a story of people's ideas evolving, it really feels as though this is very emblematic of the way you've approached not just the book, but your life, which is I'm willing to listen even to the smallest person and concede that I could do things differently.
Well, first of all, Dahlia, I too love cats. It's not either or. I love cats and dogs. Yes, the Vixen's story, it's the last chapter in the book. It's called The Dog That Changed My Life, and that is not an overstatement. I was very reluctant to get a cane. That was a huge step for me. I put it off far too long. But I got pretty good with my cane, although not as good as other cane travelers. And I yearned for more and more independence. The cane was great for me, but I was still dependent on people for, crossing certain streets and getting to certain restaurants. And the traffic and the sounds in the city are getting worse. I found myself yearning to be a little more independent. I was intrigued with the idea of a guide dog, but I never took that step because I was under the impression that to get one, you needed to go live at the facility for a month to learn to use the guide dog, which is the way there are a dozen or so guide dog breeding and training programs, facilities around the country. And they have lovely facilities, and you go live there for a month to learn to use a dog. Learning to use a guide dog is very difficult. It takes a long time, not only to learn to do it, but for the dog and the human to trust each other. And so it's an intensive experience. And all of these programs, you go live there for a month. Well, I didn't have the kind of job where I could go off and live somewhere else for a month. And so I never did it. But, and I tell this story in the book, my then 11-year-old grandson showed up one day with this podcast about guide dogs. He and his family have a dog they love. And he wanted me to listen to with him. And at the end, after they talked about their wonderful facility, they said that if you were too busy to come to the facility under certain circumstances, they would bring the dog to you. So, a light went off at that point, and I mentioned it to Edie, and we started to ask questions. And we discovered in Connecticut a program called the Fidelco Guide Dog Foundation, which doesn't even have a facility. Their whole philosophy is that the best way for a person to learn to work with a guide dog is to do it where you live, in your own neighborhood, in your own office, in your own community. And so we started to explore it, and we ended up applying and being accepted. And the whole process took a year. I like to say it's like applying to college. I had to have references, medical checks, financial reports. They did home visits. It was very extensive, and we were accepted. And they breed and train only German Shepherds. And so 4.5 years ago, this trainer from Fidelco showed up in a bus, and out hopped 2-year-old Vixen, a beautiful female German Shepherd. And the trainer spent 2 weeks with us. He lived in a hotel, and we worked together every day, learning to walk on sidewalks, cross streets, ride the metro, go to my office. We did everything that I do in my normal day. And I needed to learn to take care of the dog, because the relationship only works if the dog bonds with the human. And by the way, vice versa. And that only works if the person is the one responsible for the dog. So I had to do everything. And, I hadn't been a dog person. We had dogs when our children were growing up, but they were their dogs. They were the kids' dogs and Edie's dog. And I liked the dogs, but they were more of an obstacle for me to trip over than to play with. So now suddenly I have my own dog, and I have to take care of the dog and groom the dog and feed the dog and do everything for the dog. In fact, Edie was told by the trainer that she could only use Vixen's name once a day and pat her once a day, because the dog had to connect with me. And it all worked out. And I now have this fabulous, wonderful relationship with this German Shepherd, who, as I explain in the book, has given both Edie and me an enormous amount of independence that we didn't have before. I can now go on a walk by myself. I don't have to wait for Edie to decide that she would like to go for a walk. She can come along, but if I want to go, I just go. I can go back and forth to the court by myself. Vixen loves the escalators on the metro. So she's become a critical part of my life. I'm with her 24 hours a day, 7 days a week. She's sitting here right next to me, waiting to serve. And she's a part of our family. Edie loves her just as much as I love her. And it's just like, let me go back to the book for a minute. I explained that I didn't understand when writing a book that the writing process itself would create such deep understanding about yourself. I didn't understand that. Nor did I understand that getting a dog, I thought a dog would guide me around. I had no idea that I would develop this deep relationship with her, a very deep relationship that's mutual. And I did not understand that about humans and dogs until Vixen showed up 4.5 years ago and became my partner.
I love that the book is replete with advice for young attorneys. And I love that one piece of the advice that you've pulled on here that is really, I think, very profound is that if you are honest when you write about yourself and have to defend your views of yourself, that too will cause you to evolve and change and be a slightly different person at the other end of it. And I wish we could bottle that. I think that is kind of a level of self-understanding that we are utterly lacking in public life right now, perhaps because everybody just tweets. But
so maybe everybody should write a book and get a dog, Dahlia. That would really improve the world.
And also they should get a cat. Yes.
A cat too. Everybody should have a dog or a cat or preferably both.
The book is Vision by Judge David Tatel. It came out in June. Judge Tatel served for 29 years on the U.S. Court of Appeals of the District of Columbia Circuit. And there's a stunning line that I'd love to close with where you write, Judge, quote, "I'd been so busy deleting references to blindness from my Wikipedia page that I'm not sure I ever thought about why Lady Justice wears a blindfold." And your insights on the ways in which both your blindness and your being a judge have helped you understand both of those things. It's really an enduring, and in this very, very tense moment in American history, a very, very moving memoir. So thank you so much for coming on the show. Tell Vixen thanks for infinite patience while we taped, and thank you for all the work you have done.
Well, thank you, Dahlia, and thank you for your questions. They mean a lot to me because they tell me that you've understood the book I wrote, and that means a lot to me. So thank you.
And that is a wrap for this episode of Amicus. Thank you so much for listening in, and thank you so much for subscribing and for reviewing and recommending this show to your friends, your family, your co-workers, your co-counsel, fellow students, your professors. So very many of you have reached out in the last couple of weeks just to thank us for the work we've been doing here these last crazy few months, bringing you the weekly episodes, the pop-up episodes, the special originalism series, Opinion Palooza. I just want to send that gratitude and that recognition right back at you, dear listeners, for listening and for supporting the work that we do. Sometimes we forget that it's not us in a booth with headphones, that there's all of you out there. We're deeply grateful. You can keep in touch at amicus@slate.com. You can always find us at facebook.com/Amicus Podcast. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Alicia Montgomery is Vice President of Audio at Slate. Susan Matthews is Slate's Executive Editor. And Ben Richmond is our Senior Director of Operations. I'm going to be back in September, but Andrea Bernstein will be back with another episode of Amicus next week. And until then, hang on in there.